you are very interested in the issue of no-fault divorce and repealing it. Can you tell me why?
That's correct. My parents are undergoing no-fault divorce in New York State.
Okay.
Just observing, seeing what's taking place, how it's being adjudicated through the courts, and what I see is not something that I'm okay with, and just has led me to a lot of investigation as to what no-fault divorce is, where it came from, the historical elements of it, and what the implications are for society.
So what can you tell us about the case in itself?
Sure. I mean, generally, the case started, I would say, back in 2012 when my father started to communicate with a lawyer and try to set up a divorce against my mother. And she found out about it. It was about 2 years later, not doing anything, and she didn't have a place to live, didn't have funds. She eventually filed for New York. It's called a legal separation, which is not a full divorce. It just kind of takes care of the finances, and if custody, if there were kids underage, it'd take care of custody too, but it wouldn't allow spouses to remarry. So she initially submitted for a legal separation, and my father countered for a no-fault divorce, which is what the court preferred, and didn't have a defense against that. In fact, a lot of the lawyers tried to dissuade her from filing a legal separation, and actually ended up having her forfeit that claim. But she submitted a claim for divorce under adultery. So it's my dad's no fault against my mom's adultery. The court was just picking favorites, and they chose my dad.
So no fault trumped everything.
No fault trumps everything.
You mentioned that your mom wanted to file for a legal separation. Were there other protections that would have granted her that the divorce did not grant her?
Protections would be primarily financial, but it would still allow her to express her commitment toward my father, given her personal and religious views, to stay married and to hopefully reconcile in the future. By
the courts granting the no-fault divorce, I'm assuming, as what you've said, your mother is a person of faith. You could almost make the argument that they violated her religious liberties.
That's right, and they've come back and said, your religious liberties don't really hold up here, and it would be different without fault grounds, because if she committed adultery, my father would have a just ground, let's say, under civil law, to pursue divorce, and she couldn't use a religious argument. But under no fault, when there's no party is at fault for committing some conduct that is egregious, basically, in essence, she is not allowed to be committed to my father by law.
The interesting thing that you're saying here, there was definitely fault behind this divorce.
Yes, it was pretty clear to all of us that he committed adultery. It was more than a one-time deal, and it was something that he didn't come right out and acknowledge even when we confronted him. So in that case, why should he be pursuing no-fault divorce if he committed something that is really a offense towards the family, not just my mother, but to the family? There's
no fault that I've committed the fault.
Right.
So it's a cover-up for, basically, it's almost a cover-up for a crime.
Yeah, I mean, and I think a lot of people will say, well, adultery shouldn't be that big of a deal anymore, or, both parents are at fault, or both parties are at fault. And, I'm not one to claim that anyone is perfect, but in society and under civil law, we have certain thresholds for what would constitute a divorce that are serious enough to where someone would pursue a divorce. And just because you're imperfect doesn't mean that you can get a divorce. But when you reach certain thresholds like adultery or abandonment, at least in civil law, they recognize that as a justification for it.
Okay, so the justification for divorce comes down to certain behaviors or actions that breach an acceptable level of misconduct, is what you're saying. Is that correct?
That's correct, and that's what has been termed in the 1800s, I would say, as a general law, which basically just means that we have a common understanding in society for what that threshold is, what that standard is. So I think the Maynard v. Hill case outlines that the legislature has the civil authority to grant that. Now, people may have different views on that, but the way that the Supreme Court has viewed it is that the legislature from state to state has the ability to make those thresholds. So across the 50 states, we have certainly a lot of common thresholds like adultery and abandonment. Others have slightly different ones, but basically the idea of a general law is that the majority of the population decides what that threshold is, and it has to be specific enough to where we all understand what that means.
So then, under the idea of general law in America, all 50 states, you can file for divorce on convenience, or because I want to be with somebody else. You can file for unilateral divorce. And I think that's kind of what you're talking about when you talk about the no fault. Is that correct?
Yeah, well, it's sort of under the guise of general law, because it's kind of a blanket statement saying that, okay, no fault applies to everyone equally, in the sense that upon request or upon convenience you can request a divorce. But really what that leads to is that everybody can decide for themselves in their own particular circumstances what the threshold is for divorce. And it's basically an at-will divorce, as opposed to reaching some threshold of conduct. So it actually ends up not being a standard or a criteria for divorce. What it ends up being is a personal desire or a passion for just leaving the marriage.